Good evening, everyone. I hope I'm audible to everyone.
Yes, ma'am.
All right, thank you so much.
Yes,
So, I
ma'am.
hope you all are doing well. Thank you. Welcome to this exciting legal webinar on contemporary relevance of public international law in recent times. We are really excited to have you here today. This session is brought to you by the Legal Quorum. Before we begin, let me take a moment to introduce you to the Legal Quorum, the platform hosting today's session. So, at its heart, the Legal Quorum is more than just a law blog. It is a growing community of people who are genuinely passionate about law, learning, and meaningful conversations. We are here to make legal knowledge approachable, not intimidating. Whether it is breaking down complex concepts, analyzing important judgments, or sharing helpful career insights, we aim to support everyone navigating the legal world, be it students, professionals, or just curious minds. We believe that the law is not just something you study, it is something that shapes lives. And through the Legal Quorum, we want to make sure you don't just keep up with the legal world, but feel a part of it. Now, moving on to today's session, we are honored to have Mr. Hammaad Siddiqui as our speaker. He is currently working as an assistant professor of law at Graphic Era deemed to be University, Dehradun. Mr. Siddiqui is a distinguished legal scholar with a BLLB honors from Aligarh Muslim University and an LLM in Constitutional Law and International Humanitarian Law from Cochin University of Science and Technology. He has presented papers at national and international conferences, authored several legal publications, and played a key role in legal academia, including serving as the editor of the first edition of Sermon Juris, that is, the Conversations on Law at KL College of Law. His areas of expertise include constitutional law, human rights law, and public international law. Today, Mr. Siddiqui will be shedding light on the relevance of public international law in contemporary times, its significance in global governance, and its impact on nations and individuals alike. Sir, we are honored to have you with us. The floor is yours.
Thank you, Hershey. Thank you so much for that beautiful introduction. I hope that I'm audible.
Yes, sir.
Yes,
Am
sir.
I okay? Am I visible? And I'm gonna share my PPT. Please let me know that whether my PPT is being presented. Is it visible to everyone?
Yes, sir. It is visible.
Thank you.
No,
Thank you
sir.
so much. Is it visible now?
Yes, sir.
Okay. Thank you. So thank you, Legal Quorum, for having me and providing this platform to me and as well as to all the individuals out there. And the topic for today's discussion is something very contemporary and very relevant for everyone because we need to know that what is happening around the globe in India as well, and how India is dealing with such kinds of contemporary issues when it comes to international law, and what are the global affairs going on in respect to international law. Now, first of all, we need to go to the basics of PIL, that what is public international law and how it is being governed on the very initial stage, and what are the being few definitions that how we can conclude the definition of public international law. So basically, when we talk about public international law, which is also known as the law of nations, and international law, and it's a body of customary and treaty rules. Now, when you talk about its customary and treaty rules, it becomes binding in nature. So, whatever laws or whatever rules we are following out in the global affairs, those are somewhere involved of customs or treaties. Now, treaties are always written in nature. Sometimes they might be also oral in nature. But once two states give their consent, it gets binding in nature. So when we talk about treaty on international level, it gets binding on the states. And when we talk about customs, which are the practices which have been coming on from the time immemorial, those are the customary practices. Now, when we talk about custom and treaty, it becomes very important while we are talking about the public international law, because this is what the international law talks about. The entire law is being revolving around the treaties. And if there is no treaty, or if there's an absence of treaty, the entire law will be revolving around the customs. And these two, treaties and customs, which are like very key important areas, or I would say that very two key important words, are very important for the public international law, because they are intercoursing with each other, they are governing the global affairs, they are governing the customs of the individuals like refugees, there might be extradition people, and obviously the treaty. For example, we can have extradition treaty between the two countries. So this is how the international law is being happening. Now, when we see this definition which has been given by Oppenheim, there was some kind of loophole. So somewhere it was incomplete. So now we are having an revised definition of Oppenheim. Are my PPTs visible?
Yes, sir. Yes,
No,
sir.
no.
Is it
Sorry,
getting forward?
sorry to interrupt, sir. I feel that slides are not getting changed.
Okay, okay, okay. I
It's
would
not
just
visibly extra to me. Sorry.
just give me a second. This is some. Is it visible now?
Yes, sir.
Yes?
Definition of PIL. Yes, so we were talking about the two concepts in public international law, which is the customs and which is the treaties. Now, treaties and custom becomes very important, and always remember that these two are legally binding. So once the state has come into an agreement with the other state and they have gone into an treaty, it becomes very much binding in nature. So, for example, I would say if India and UK are coming into a treaty or for extradition for Vijay Mallya or Mehul Choksi, the one who are being extradited, this is happening on the basis of an extradition treaty, which is being between India and UK. So, whatever laws are being happening, it is happening only and only on the basis of the treaties. So that's why it has become legally binding. But as we were moving forward, somewhere we felt like that this definition given by Oppenheim was not complete. And that's why we are having a second definition that is a revised one, where it says that international law is the body of rules which are legally binding on the states, which I've already covered when they intercourse with each other. Now, these rules are not only confined to the states. Apart from states, the international organizations and the individuals will also be a part of the definition. So, in the earlier times when public international law was evolving, only the states were the subject matter, which means that the states were being governed and the states were only being taken into consideration. But then we felt like there was a kind of a criticism going on, and then we included international organization that even they will be a part of the definition of international law. Even individuals like refugees, even they will be a part of international law. So now, apart from states, we are having two more subject matters. And those two subject matters are also international organization. It might be a United Nation, and individuals, it might be refugee. For example, in order to make it more clear and substantiate for you people. So this is how the international law definition is working on the very ground level. Now, as we are moving forward, to the next slide, which is something very important to understand. And I would request that everybody should focus on this particular slide, where we are talking about how effective and how the international law is being implemented on the ground level. So also there's a theory, there is a kind of a debate where we see that whether it's a weak law or whether it's a very strong law. And if you say it's a strong law, then what are your arguments? If you say whether it's a weak law, then what are your arguments? So let us discuss about things that whether international law is a weak law, strong law, and how effective it is. I mean, there are laws, and for example, in order to substantiate, in our country, we are having n number of laws, right? Now, if that law is not more effective in nature and it is not being implemented on the ground level, then what's the use of having the law, right? It's totally and completely useless. For example, we are having a law that the Supreme Court gave guidelines in West Bengal case. How to arrest an accused, right? It's a very landmark judgment. Now, if you're not following that particular guidelines that how you have to arrest an accused, or you are not following Article 22 of the Indian Constitution, where you're having the rights while the accused has been arrested, then what's the point? What's the use of having the law? So, if we are having a law, we need to make it sure that it's being very effective and it's being implemented on the ground level. And we as citizens are going to tell to the executor that yes, this is how the Supreme Court and the Constitution, the law of the land has given us the rights, and we need to make it sure that it's being implemented, right? So in the same way, it goes for the public international law, that we are having laws out there. We are having extradition laws. We are having a lot of treaties. We are having laws on this extradition, international law. We are having laws on maritime laws, climate change laws. So we are having a number of laws. Now the point is that how these laws are strong in nature, how effective they are, how far these sovereign countries are following these laws. That is something, another important question to answer. Because at the end of the day, we all countries in the world out there, we are sovereign in nature. We are independent in nature. US cannot dictate on UK. UK cannot dictate on China. China cannot dictate on India. India cannot dictate on Bangladesh, which means that we are independent in nature. We are sovereign in nature. And now we need to see that if tomorrow there is a sanction, how far it is going to be effective. And that's why I've included this definition of law by the Austin. That Austin says that law is a command of sovereign that is backed by sanction. Now we have a law, we have a sovereign identity, that is India or any other country being it supreme in nature. And if we are not following the rules or the laws made by the parliament, then they would be sanctioned, right? That is something, a very appropriate definition given by the Austin in terms of law. I hope everybody would agree with that. Now, and that is something on the national level I'm talking about. We are having executive, we are having legislature, we are having judiciary, we are having three organs of government, and governed by the separation of powers, right? Now, the same thing goes for the international legal framework. Try to understand the point. Try to understand the concept. Concept is very important, you know. You will find things in book and you can just mug it up. That's a different story. But getting the concept is important here. So when we are talking about legislature, judiciary, and executive, that is confined in India, and we are having three organs of government, in the same way, we are having this kind of legal framework in international arena also. We are having legislature also, we are having judiciary also, we are having executive also. We're having International Court of Justice that works as judiciary. We're having United Nations that works as a legislature, and as well as the executive. And somewhere we are having the role of the sovereign countries in order to make sure that it is getting implemented. So somewhere these countries are also doing the role of the executive, making sure that yes, the laws are being implemented in their own countries, and that is being done by the help of the ratification in the treaties. So now the question comes that still when we are having such kinds of classification, we are having the National Court of Justice, we're having United Nations, the largest peacekeeping nation in the entire world, but still why such wars are coming in? That is the very main idea behind this particular slide, that we're having International Court of Justice, we are having United Nations also, the World Committee, Harmony, peacekeeping bearers, but still we are having wars like Israel and Gaza, we're having wars like Russia and Ukraine, and these wars are like being still going on from the last couple of months. It's been like more than a year, and hundreds and thousands and lakhs, around 30, 40, 50,000 people, if I'm not giving an accurate number, but still around 50,000 people have lost their life, including elderly women and children in Israel and Gaza war. Coming to Russia and Ukraine, again, we have lost thousands of lives while the Russia wants to invade Ukraine. So this is a kind of a scenario which is going on the global level, right? And this is a very contemporary issue which is going on. So the question comes in that what international law is doing about it. And that's why I have written this question. Is it a weak law? So yes, my dear people, international law is a law, but it is a weak law. The reason why it's a weak law is that because there is a law. Law is existing out there, no doubt, but that law is not effective in nature. That law is not being implemented on the ground level. And there, in fact, there's no one to implement it, right? Because at the end of the day, we are an independent country. We are sovereign in nature, and we can do whatever we want. The Russia cannot dictate us, just like I told you, the US cannot dictate us. We can do whatever we want. So even if there are being sanctions by the International Court of Justice, for example, there's a lot of sanctions coming in from the International Court of Justice for Israel, but Israel is not listening because Israel is an independent nation. Israel is a country. Israel is sovereign in nature. And that's why Israel is not at all listening to the International Court of Justice, and they are doing whatever they like. They are not following the international law. They are not following the rules or the sanctions coming in from the International Court of Justice, even though it's a law, even though it's a judicial body, but they are not listening to it, which means that the gravity or the very meaning of the international law is somewhere lost. The law is there, it's a good law, the global affairs are being governed, no doubt. But when we see that United Nations is able to do nothing, absolutely nothing they are able to do, they have done nothing, they are unable to stop the wars, the International Court of Justice, even they have done nothing, they are unable to pursue the matter in a very concrete manner. So somewhere they have failed to do so. Not somewhere entirely, because even if you criticize it, give me 2 seconds. So even if you critically analyze it in terms of United Nations, in terms of International Court of Justice, what they have done, what they have done when it comes to prevent the wars, like a large scale massive war where thousands of people have lost their life. I mean, it's scary. It's very scary when you think about it, that those innocent people, those innocent civilians, which are being very much protected under the international law, they are being bombarded like anything. They're sleeping at night, and the morning they're not waking it up. They're like under the rubbles, the warplanes, the bombs, very uncertain life, and the lives, the homes, the property, the loved ones. There's a huge destruction out there, which is still going on. The same goes for the Russia and Ukraine also. So yes, even though international law exists, but yes, international law has done a very little about it, including the United Nations, which is meant for the global peace and harmony, including the International Court of Justice, which is for the law and order in the entire globe of affairs. And that's why I wrote this question, that whether is it a weak law or not. So yes, it's a law, but it's a weak law. The effectiveness and the implementation, it's somewhere missing. The countries being independent in nature, being sovereign in nature, they're not listening to the law or to the ICJ. So moving on to the next slide. I hope this slide was clear to everyone. In the same way, we're having another contemporary issue, how international law is governing. The another interesting issue which we're having is on the refugee crisis. Because when you see this Israel-Gaza war, when you see this Russia-Ukraine conflict, or whether you see the human rights in Afghanistan or in Pakistan or in Syria or Yemen, or nowadays we're having large massive scale in Turkey protest. So when all these things are somewhere being governed under international law, and this is the reason why we are talking about it. We have talked about the wars, and now in the contemporary scenario, and now we'll be talking about the refugees, that how the definition of refugee is coming into existence. What are the refugee crises pertaining in India as well as outside India? We need to know, because that is happening something in our own country. So now let us see that from where we are getting the definition of refugee. Article 1 of the 1951 Convention on the Status of Refugee says that when we are having a very well-founded fear of being persecuted. So please make a note of this definition. Keep in mind whatever I have highlighted, that is very important. When we are having a very well-founded fear of being persecuted, now we are having 5 reasons for that. First reason is race. Second reason is religion. Third reason is nationality. Fourth reason is membership of a particular social group. And fifth is political opinion. Now, these are the 5 wide grounds on which persecution might be happening, and you can avail the status of refugee. Now, if you critically analyze this particular definition, you will only see 5 grounds that is race, religion, nationality, membership of a particular social group, or political opinion. Apart from this, any grounds will not be coming into existence for taking the status of refugee. That is something very important. So, for example, you might be having a kind of a environment hazard, and you want to take a kind of a status of refugee. So you cannot do it, even in wars. Even in wars, if you critically analyze it, it will not come into the status of refugee, because refugees are those people who are coming from one country to another country. They are crossing the land, they're crossing the territories. When, what is the situation? The situation is that they are being prosecuted, well-founded fear of being prosecuted on the name of 5 grounds only. This is according to the particular definition. And this is one of the reasons why we criticize it. We criticize the definition of Article 1 of 1951 Convention because it's a very narrow definition. When I say it's a narrow definition, I mean that you cannot talk about war, you cannot include the victims of the war, you cannot talk and include the victims of the environmental hazard. It might be an earthquake, it might be a famine, it might be a drought, it might be a wildfire, or it might be a war tomorrow. So under all these specific circumstances, they will not come under Article 1 of 1951 Convention, right? Only these 5 grounds will be coming under Article 1951 Convention if you have to take the status of refugee. And refugee are those people who are crossing the boundaries from one country to another country because they are being prosecuted in their own countries on these 5 grounds, right? So moving on next to the slide, principle of non-refoulement, Article 33 of 1951 Convention related to the status of refugee. Please note down the convention name. The convention name is 1951 Convention relating to the status of refugee, right? Now, Article 33 of that convention talks about the principle of non-refoulement. Principle of non-refoulement is something, again, very important and a very interesting concept to know about, right? So it's being said in Article 33 of the 1951 Convention, and it states that no country shall send back the refugees or the people who are having well-founded fear of persecution to their home country, to the country of origin. So, for example, if anybody is coming here from Bangladesh and they want to seek a refugee, status of refugee in India, right? The Indian government cannot send them back. Why? Because their Article 21 is at threat. Their right to life and personal liberty is at threat. They're having well-founded fear of persecution in their home country, in their country of origin, where they have been born or they have been living. And if they continue to live, they might be killed because they are being persecuted. On what grounds? They are being persecuted on the grounds of religion, race, nationality, membership of the social group, or the political opinion. So always remember that if we want to give the status of refugee, we can only give on the basis of 5 conditions that is mentioned in Article 1, not any other that. That is something very important to remember. Second is Article 33 of Principle of Non-Refoulement, that a country where the refugees are trying to take the protection, where they want to come and seek shelter, that country should not send them back. Why the country should not send them back is because they are having well-founded fear of persecution in their own home country. Because if they will go back to the home country, they might be attacked, they might be killed. Recently, I think so in last 1 or 2 years, you might have heard few of Myanmar, not 1 year, but yeah, a couple of years, around 3 or 4 years, when when the democracy in the Myanmar failed and it was brought down and it was overtook by the military, right? So in that case, the democracy was killed in Myanmar, and there were few people who escaped Myanmar and they came to India, right? Why? Because they were voicing against the military rule in Myanmar, because all the political leaders, all the prime minister of Myanmar was taken into custody and they were thrown into jail by the military, by the Myanmar military. And during that process, few of the people came to India. Now it is the Indian perspective, or it is a duty of the Indian government to provide shelter to them. Why? because if they are might send them back, they might be killed, they might be prosecuted on the name of political grounds because they're having a political opinion. Just like I told you, there are 5 grounds on which persecution might happen. It might be on race, it might be on religion, it might be nationality, it might be social group commitment, or the last one is political opinion, which means that dissent. Always remember that right to dissent is a very integral right under Article 19(1)(a) of the Indian Constitution. You can criticize your policies of the government under 19(1)(a), and that is your right. So freedom of speech and expression has, and it's include right to dissent also, because at the end it's a democracy. So in the same way, it goes to the Myanmar. Few people came in here, and we cannot send them back. That is the beauty of the principle of non-refoulement, that we are trying to save lives. So again, international law is there, and we are trying to make it sure that we are implementing it on the ground level. So if you're understanding my contention, the principle of non-refoulement is a very beautiful notion out here, because we are trying to save the lives as well as we are trying to save their lives, and we are giving the protection to them because they are having well-founded fear of persecution in the other country, and this is the reason why we are giving them protection, and now they are safe. For example, Dalai Lama. I hope you might be very much well known with this figure. Dalai Lama is from Tibet, and he is having well-founded fear of persecution by the Chinese authorities, and the Indian government has given him an asylum, and that was being converted into refugee while it was being verified. So the first stage is asylum. Once asylum credentials have been verified, it get converted into the refugee status. So Dalai Lama is enjoying the status of refugee in India. He is being very much protected. The China cannot do anything, even though China is against Dalai Lama, because Dalai Lama is asking for a separate Tibet, a separate land. So this is how the international level global affairs are being going on. So let us see how what are the crises going on in India when we are dealing about the refugee crisis. It's a very global contemporary issue, and we should be aware of it. Before that, we are having some relevant terminologies. Yeah, I told you what is asylum seeker, what is illegal migrants, what are migrants, and what is IDP. IDP stands for internally displaced people. Always make it sure that IDP will always belonging to one country only. They can move from one state to another state because of some kind of economic conflicts. It might be due to some kind of earthquake. It might be tsunami. So they are moving from one state to another state, but they're not crossing the boundary. Always remember, they are not crossing the Indian territory. They will be moving within the Indian territory from one place to another because of due to certain reasons. It might be natural calamity. So those are internally displaced people. Now, illegal migrants are those migrants who are coming from the another country illegally. Now, when I say that they are coming from another country illegally, it means that they are without valid passports, valid visas, valid documents, valid travel documents. They're having nothing. They are crossing the boundaries illegally. For example, if you have seen this movie Donkey, how the Indians were crossing the boundaries illegally in order to go to US, and now Mr. Trump, the president of USA, is deporting them back. It's a very contemporary issue and a contemporary global news right now, right? In this way, how okay, we'll be taking these case laws and questions afterwards. So how this thing is happening right now is something very important to know, that how illegal migrants are crossing the boundaries, right? And that to international boundaries. So this was very beautifully depicted in the movie Donkey, that how this illegal cross-border migration is happening, and this is the reason why Mr. Donald Trump has deported them back. Now the third instance of migrants are those people who go for economic job from one state to another state. For example, the workers of the labor class of Bihar might be traveling to Kerala for some kind of good job opportunities or economic opportunities. So those are again moving from one state to another state, but they are not crossing the boundaries. Asylum seeker, just like I told you, that when we when we want to take the status of refugees, the very first step is asylum seeker. So, for example, I'm a refugee coming from another country. I'll be requesting the government to please give me asylum seeker. Please give me shelter. Why? Because I might be prosecuted in my home country. Now the government would be asking about the documents, that what are the relevant documents, how would you prove yourself? Once I have proved my identity, I have proved my documents, I have given them the reasons, and the security process has been cleared, the government has done their verification, then I'll be getting the status of the refugee. So firstly, I will be asylum seeker, and once my status has been verified, my documents have been verified, my claims have been verified, I'll be getting the status of the refugee. That's are the relevant terminologies specifically revolving under public international law. Now, we will see that what are the contemporary issues in public international law pertaining to refugee, and specifically they also pertaining to India also. Because when you talk about this, just like I have talked about the Myanmar refugees, right? That during the democracy was collapsed, few of the people came from Myanmar to India because they were having some kind of disagreements with the government out there. And that's why they fled to India. We are also having refugee issues in Afghanistan as well as in Rohingyas. Rohingya issue is something I think so very contemporary issue, at the same time very important. Why? Because they are not having any homeland, first of all. Their own country in Myanmar are sending them back. They are not ready to accept these Rohingya refugees, and they are in lakhs and lakhs of number. They are being persecuted in their own countries. That is something very important to know. Am I audible and my slides are visible? Can anybody let me know?
Yes. Yes, sir.
Yes, sir.
Thank you, thank you. So yes, talking about the Rohingya refugees. Now, Rohingya refugees are coming from the Rakhine state of the Myanmar, and they are in very large number, in lakhs and lakhs. And now they are trying to come into Bangladesh, as well as they are trying to come into India. They are already in Bangladesh, in fact, and they are already in India. And now the concern is that what are the laws for the refugees in India? So let me tell you, first of all, before I go into the intricacies, India is not having any specific legislation in order to govern refugee. That is the very first point to be noted down. We're having laws, but we're not having any specific laws for the refugees governance. So that is first point, and that's why we're having a lot of ambiguities, a lot of confusion. Now, second thing is that whether the Indian government is trying to send these Rohingya refugees back. That is another point to be discussed. Before that, I will tell you that what is the situation of Rohingya refugees and how they have come. Now, Rohingya refugees were being persecuted on the name of nationality as well as on the name of religion in their own country, in Rakhine state of Myanmar. They have been killed, they have been persecuted on a very large scale, on a very massive scale. And now, in order to save their lives, in order to seek shelter, they came to Bangladesh. In Caesar island of Bangladesh, I think, so not pretty much sure about it, is the largest number of, the Rohingya refugees are living there. And I think so that is the largest number of areas in terms of refugee also in the entire world. So when we talk about the entire world, I think so Caesar is a place in Bangladesh where a lot many refugees are living there in the world. So which means that we are having lakhs and lakhs of people who are homeless, who are stateless. And what about the human rights? What we can do about it? And how our law of the land, how our Indian constitution is going to give the rights and give them basic protection. And what about the principle of non-refoulement? These were all reasons that why I've already discussed what is refugee with you. I've already discussed the principle of non-refoulement, Article 33 of 1951 Convention, so that the picture gets clear that what we are talking about. and what are the relevant laws out here. So in order to make it show that this is the reason why I gave you Article 1, this is the reason why I gave you Article 33, that if there's a well-founded fear of persecution, the country should not send them back. In the same way, the Rohingya refugees who are having well-founded fear of persecution, they should not be sent back to their home country because they will be killed. They will be prosecuted. But now the Indian government is having a stake that they might be in danger to our national security ground. So that might be one of the perspective. But then again, we need to prove that ground. That why? What are the reasons that how they can be more dangerous or some kind of complexities might come in national security ground? Because that is the only reason why the union government wants to deport them back. Even though we are having Article 33, which says that they should not be deported back. Why? Because they're having well-founded fear of persecution, and we need to save them. We need to give them shelter. We need to protect their basic human rights. Even our country, our law of the land, that is Constitution of India, which is supreme in nature, protects the foreigners. For example, Article 14. For example, Article 21 of the Indian Constitution. Just give me a second. I think so. I lost my camera. Yes, am I visible and audible now?
Yes, sir.
Yes,
Okay,
sir.
my video is on.
Yes, sir.
Yes.
Okay, thank you for the response. So we were talking about that what the Indian law and how the Constitution of India is doing a good job in order to protect the basic human rights of the Rohingyas. Because when you talk about Article 14, the right to equality, when you talk about Article 21, the right to life and personal liberty, even these clauses, these important essential provisions are applicable to the foreigners also, which means that these are very much applicable to the refugees also, and even they can claim it. So the refugees coming from Pakistan or Bangladesh or from Myanmar, even they can claim Article 21 of the Indian Constitution. Even they can claim Article 14 of the Indian Constitution, because that's a basic human right. And basic human rights are given to you the moment you are born. It's not that you are getting the basic human rights after you turn 18, after you turn 19 or 20, or you get basic voting rights. No, it's not like that. These are very much ingrained in you the moment you're born. They cannot be taken, they cannot be abridged, they cannot be infringed. So that is a very essential and the very crux of the basic human rights. And the government is not giving to us. Please, my dear people, please don't get this notion that government is giving you some basic human rights and some rights and duties. No, it's the Constitution. It's the law of the land that is giving you the right, which is supreme in nature. So in the same way, our Constitution is giving some rights to these foreigners, to these refugees, in order to protect their personal liberty, in order to protect their human rights, which are very crucial in nature, which cannot be taken away, which cannot be infringed, which cannot be abridged. And it is being given to you the moment you have been born. It's universal in nature. And it is applicable to me as much as it's applicable to you, or it is applicable to the foreigners, which are the Rohingya refugees, or the Myanmar refugees, or the Afghan refugees. We know the situation in Afghanistan is not good. The basic human rights in Afghanistan is also at stake. Should I continue without my video? If it's not a I think so. I lost my video, right?
Yes, yes, sir.
Okay, so are you comfortable with the? Should I go on?
Yes, sir.
Please proceed,
Of
sir.
course.
Not an issue at all.
Okay, so yes, when we are talking about the basic human rights, which are universal in nature and which have been given to everyone, so it has been given to us, it is given to me and you, it is given to the Rohingya refugees, it is given to Myanmar, and it is given to Afghan refugees. But when we are talking about the Rohingya refugees, the Union government is in a contention that they should be sent back. Right? They should be sent back because they might be national security ground, but still this has to be proved. It is still pending in the court. Then we are having Myanmar refugee. We are having few case laws also. Let me see that which are those case laws, because case laws are also very important when we are talking about such kinds of global affairs. We're having one case law, that is Mohammed Salimullah versus Union of India, and we are having another case law, that is Nanta Haskar versus State of Manipur. I've already discussed Nanta Haskar versus State of Manipur with you people, because it's a 2021 case. While I was telling you that when the democracy fallout and we were having the military rule in the Myanmar, so at that time few journalists came to India, and the High Court of Manipur was so good enough to provide them protection. So the High Court of Manipur gave a judgment. You can refer to this judgment. It's a very good judgment, that how High Court of Manipur have brought Article 14, right to equality, Article 21, right to life and personal liberty, into existence, and how they have applied these important notions to the refugees also, for the protection of refugees also. Otherwise, they might be killed if they are going back. And also the importance of the principle of non-refoulement, that we need to follow international law. We cannot get away with international law. And then we are having one case, or I would say it's an interim order. It's an interim order from Muhammad Salimullah versus Union of India, and where we are, the same goes for the Rohingya refugees also. And the Supreme Court has said that they might be deported back, but we need to know the entire process. So let us see that what the Supreme Court gives the final judgment on it, because the judgment is still not out, so we cannot make any kind of statements right now. Now the last important question comes, that whether India is bound to follow the 1951 convention relating the status of refugee under international law. Now I told you that we are having treaties, we are having convention, and for that we need to sign it. It's an amicable one, and if we have signed it, then that agreement becomes a treaty. And once it's a treaty, then the country has to follow it. In the very first slide, if you remember it, that if it's a treaty, it's binding in all the states and they have to follow it. They cannot say no. There might be few situations on which a treaty can be terminated, but once you have signed it, once you have entered into an agreement and you have ratified it, it's a treaty and you have to follow it. But in this case, India is whether bound to follow or not is the important question, because India is not a party to 1951 convention. That's the important point you should note. And this is the reason why the Union of India, the government of India, is taking the stand that we are not obliged towards 1951 convention relating to the status of refugee. Why? Because we are not a party to it. We have not signed it. So India has not signed that particular convention. So India can follow the treaty, cannot follow the treaty. It's up to India. They cannot bind anyone. That's the important faction you should know, that why the Union of India is sending the Rohingya refugees back. They are stating that we are not bound to follow the definition of refugee, the principle of non-refoulement, and we can send them back. So, but again, we need to see that what about the human rights? What about Article 21? What about Article 14? Because in the case of Nanta Haskar, state of Manipur, we have a very good judgment coming in from the state of Manipur, where the High Court said that they are very much protected. Under principle of non-refoulement, they should not be sent back because they might be persecuted. Article 14 is there, Article 21 of the Indian Constitution is there, so they are very much protected. I would request you to please go through this judgment once you get free. So with this, we will be winding up this session. And if you have any doubts, please let me know. Whatever we have discussed about the refugees, it might be the contemporary happenings, about the definition, please let me know if there are questions on the floor.
Thank you so much, sir, for your insightful discussion. That was truly enriching. As we all know that public international law remains vital in addressing global challenges like climate change, digital governance, and refugee crisis. And the recent developments also highlight its evolving nature through the landmark opinions, the emerging norms in cybersecurity, and the reforms to multilateral institutions seeking to bridge the North-South divide in an increasingly multipolar world order. So once again, thank you so much, sir. And now we will open the floor for some questions and discussions. So as sir said that if you have any questions, please drop them in the live chat and we will address as many as possible. Sir, we had one question asked as could you please explain us the case of NHRC versus State of Arunachal Pradesh 1996?
Yes, are we having questions?
Yes, sir.
Yes, Archie, what's the question?
So the question is that explanation on the case law of NHRC versus State of Arunachal Pradesh 1996.
Okay, so this case was regarding the protection of human rights coming from the NHRC, National Human Rights Commission. And am I audible?
Yes, sir.
Okay, okay. So again, we are talking about the Human Rights Commission, and we are talking about the tribal areas. And just like I told you, that Article 21 of the Indian Constitution is for Indians also, and it is also for the foreigners also. Now, when we talk about the state of Arunachal Pradesh, we had a kind of tribal people, and those tribal people are also known as the Chakmas. Now, we have approached the court saying that whether they are being protected or not under the Human Rights Act because they are the tribal people, and these tribal people are coming from the state of Arunachal Pradesh, and they have also known as Chakmas. So Chakma is basically, I think so, it's a kind of tribal word, and that's why we are referring them as a tribe, as a tribal area coming from the Chakma. And so when they are coming from the northeastern states, so few are coming from the Assam and Tripura and all, but there were many people who came from Bangladesh, I think so. So when they came from Bangladesh or from the neighboring countries, they have taken shelter in Assam and Tripura, right? So Assam and Tripura, like you might be knowing that there are one of the 7 states in northeast, and just because they are coming from the another state, they have taken shelter in Assam and Tripura. Now the question was that whether they are very much protected under the Indian laws or not, or whether we are going to protect them or not. What about their citizenship? So this was again brought by the committee that is known as National Human Rights Commission, that whether we are going to protect them or not, or whether we are going to provide them shelter or not. So the question was said that regarding the shelter, that is asylum seeker. Asylum seeker provision is Article 14 of the UDHR, that is Universal Declaration of Human Rights, that we need to give them shelter. But when we are talking about the granting of refugee, then we need to identify the claims. We need to identify the procedure. So the court said that you need to identify the documents, you need to identify the process in order to give the claim of the status of refugee. But before that, You can give them kind of a shelter under Article 14 of UDHR, and you can protect their human rights, right? But in order to make it sure that whether you're granting them status or not, you need to verify it, right? Any other questions?
Yes, sir, we have another question. So the question says that if a country is bounded by any treaty or conventions and fails to follow its provisions, then are there any such effective and enforceable international provisions against such action? And second part of the question is also there. So will you answer the first part and then follow up with the second?
Yeah. So that is a important question. Thank you, Nandita, for asking me such a very solid question. That we are having a lot of treaties, we are having a lot of conventions, we are having a lot of rules on international global affairs. But when we are not following it, when we are breaking the law, and even if ICJ is trying to put sanctions on it, even those sanctions are getting null and void. Even those are not effective in nature. This is the reason why we are saying that law is there, even command is there, even sanction is there if you're not following it, but that is of no use. The legal order is not getting into community. For example, in India, if you do a wrong, there will be a liability. If you do a crime, there will be a penal liability and there will be consequences. But in international law, if you do a crime or if you do a penal this kind of stuff, they would be sanctioned. But again, the country says that, okay, we will not follow your sanction. We are an independent country. We don't give a damn about you, and we will go forward with our own thing. So it's not effective in nature, and that's why such international provisions are very weak in nature. They are laws. I accept that, and they are laws. They are being followed sometimes. Sometimes they are not followed. But when the sanction is coming, countries like these powerful countries like USA and Russia, they are not even following the sanctions. So because they are independent, they are supreme in nature, they are sovereign. And this is the reason why it becomes a weak law, right?
So
What's the
the
next
next
one?
part of the question. So the next part of the question states that what if a country which is not ratified to any convention and treaty and violates human rights? Are there any international actions against such country?
Again, it's a very good question to ask. And again, there are no any concrete step which can be taken by the other country, right? For example, I told you that 1951 Convention relating to status of refugee, India is not a part to it, but India is bound to follow it. Why? Because we are having customary regulations that we cannot go and infringe fundamental rights. We have principle of non-refoulement, Article 33, that we cannot send the refugees back, but still we are sending them back. We are putting their life at risk. We are putting their human rights at risk. So this is the reason, and the other countries cannot do so, or the other countries cannot do much more. Why? Because if they are doing so, they are interfering in the internal matters of the other countries. So the other countries avoid doing that because it's international global affair, and we cannot interfere in the internal matters of the other country. Why? Because we are sovereign in nature, we are supreme in nature. So this is how it is happening. Yes.
So there's one more question. So the question is that can you please also explain that even we have an treaties and customary laws, why there is a deprivation of basic right in Afghanistan? Like women and children are facing too much
Right,
deprivation of
right.
their
I
basic
agree
right.
with that notion. I agree with that thing that even though we're having the national law, legal order, we're having the national law, still the women's right or the human rights are being stricken, particularly in Afghanistan, which is being ruled by Taliban, because they are not following the national law. They are saying that we are independent country. They are saying that we are being followed by the Islamic or the Sharia laws. We are doing it. So in order to make it sure that they are doing it, we are they're having a lot of ambiguities in that, and that's why they are not following it, because at the end of the day they are telling that we are independent in nature, we are sovereign in nature. They are not bothered about the international law. They're not giving any weightage to international legal order. So this is the reason how they are saying that we are not going to follow international law. So that is the reason why we things get a little ambiguous. That even though we are having laws, but the governance is like very, very bad. The effectiveness and the implementation of international law is very weak in nature, and
I have a question, sir.
the countries are not ready to follow it. That is a major problem. The country knows that it's a law, the law is there, but the countries are not ready to follow it, and that's why it becomes a weak law, and that's why their sanction become ineffective, and that is the reason why international law becomes a weak law. I hope you're understanding my point.
I have question, sir.
Yes, please hurry up, tell me.
First, thank you, sir. I really admire your presentation.
Yes.
I am a lecturer at Ryan School of Law, and now I am teaching the course Public International Law. You
Yes, sure.
state the two arguments regarding the effectiveness of public international law, especially the Hippocrates idea, who was assumed as a father of public international law, who admires the existence of public international law, and on the other hand, the idea of Austin or John Bolton, who oppose public international law as its lack enforcement and implementation. Yes.
Koshi, I didn't got the question. Can you just let me know what's the question?
My question is, what is your personal view as stand regarding the existence and effectiveness of public international law, as you are expertise on public international law? What is your personal view? This is my first question.
Personal view
On the existence and effectiveness of public international law.
Afghanistan.
Public international law.
Yeah, you're talking about Afghanistan, right?
No,
Okay.
I said that. Are you hearing me? Sorry.
I think there's some network problem. Can you just write it down?
What is your personal view?
Okay, yeah, I got that. What's the country name?
Mr. Shevich, please type it into the chat box. That would be
Okay.
easier for us.
I can see one question from Khushi Sharma that the countries aren't bound by those laws. So Khushi, I want to clarify that the countries are bound by these laws, but sometimes the countries are not following it. That's the major problem. And why the countries are not following it? Because the country is saying that we are independent, we are sovereign in nature. Either we will follow, either we will not follow. And if there is a sanction coming from the countries or from the ICJ, even they are least worried about it. For example, the USA is doing a lot of sanction on Russia. Then Russia is saying that it doesn't affect us. We are going to trade our oils to other countries. We are going to sell our oils to other countries. So even these sanctions are not effective. So these laws are bounded. The states have to follow these laws once they are coming into a treaty, but they are not following it. That's a major problem. Yes, it's a violation, and sometimes sanctions are there. And if sanctions are there, sometimes it is effective and sometimes it is not effective. But most of the time, it's not effective in nature. The countries are doing whatever they want because they are sovereign in nature and they are supreme in nature. Nobody can dictate their terms and conditions on the countries. So even if they're sanctioned, we are not following it. For example, there's a lot of sanction on Gaza, on Israel coming from ICJ, but still they're not following it. So it becomes weeks. I hope you're understanding. So are we done with this? Khushi, should we wind it up?
No.
Sir, the question has been raised by Shevit. There are two questions.
Yes, Shweta, that's a good question. I was unable to understand because of some technical glitches out there. So, what is your personal opinion regarding the existing public international law? So, it's a very nice question, Shweta. I really appreciate that. So, basically, what is the existence of public international law is something very important, something very crucial, right? Either it's a global trade, either it's global affairs, either it's diplomacy, either it's climate change. We're having a lot of stuffs under global affairs, and we need to understand that all these stuffs are important while we are dealing with public international law. So the existence of public international law is something very important, very crucial, and very mandatory. There are no if and buts out there, right? But the point is that how far this international law has been effective and how far it's been implemented, and what is the ground reality we are going through it. Because if you see the wars going on, the United Nations is able to do nothing about it, the ICJ is unable to do anything about it. So it becomes a weak law because even though sanctions are there, sanctions are not effective. The countries are not listening. The countries are not following the international law. They are breaking the law, and they are even the sanctions are not having that much of effect. So I understand that there are loopholes also, but when you see about climate change, when you see about diplomacy, when you see about extradition, when you see about environment, you're having a lot of good points coming under international law. So the existence of the international law is important, but there are loopholes, there are criticisms of international law. On that we need to work on. Second is that how we can mitigate and put solution for the two extreme interests of state sovereignty and the protection of human rights. Yes, that's a very good question to ask. And I would say that this is some kind of an area of conflict which we are going through nowadays, because whatever I have talked about, you're talking the exact thing. Because Israel is not listening to ICJ, the Russia is not listening to ICJ, or anybody else is not giving any kind of importance to the treaty, and they are breaking the law. So one of the good condition is that we can have a global constitution, and that is known as global constitutionalism. I know this might not, sound as a practical notion for you people, but we can try for a global constitution, which means that just like we having Constitution of India, we can also have a global constitution throughout the world, one constitution for the entire world, which has been ratified, which has been clarified, which has been accepted by all the countries, by all the member nations. And if there have been any violation, there will be sanctions and there will be repercussions. But global constitution, it will take a lot of time to become a reality because bringing all the countries under one umbrella, it might be a major task. So yes, that was my answer to your question. I hope you are satisfied. Show it.
Thank you. My last question is why India not sign or ratify a specific convention for refugees, even if the principles in the constitution also applies for refugees? Why India not ratify a specific convention for the protection of refugees?
That's a political question. I don't have much idea that why did India signed about it, because that was long way back. We are talking about 1971, and what is the political situation surrounding at that time? It might be lack of resources, it might be lack of time, it might be lack of opportunities. So because we need to fulfill our own resources, how can we give resources to other countries? So yeah, it might be regarding resources, and it's a kind of a political issue also, that why India has not signed it. So yes, that's for my side. Anything
Sorry,
else?
how we can access a certificate for today's session? Sorry.
Sir, there is another question from Nandita. Without
Yes.
effective laws, how would
Harshit, we will be taking this last
the...
question because I have some other stuff also.
Yes, sir. Sure.
Yes. So I agree with the notion of Nanita that without effective laws, how would we unable to maintain the world peace and harmony? Isn't harmony can't be within the international organization? It's yes, that's where I should not use this word of hypocrisy, but yes, that's where we are lacking enough. We are having laws, but we are unable to enforce them. I agree with the statement that somewhere the policies are not being executed in the ground level, and that was my contention throughout the lecture I've given, that we're having laws, we're having good laws, but implementation is not happening. So this is the reason that why it is being a weak law and how sanctions are ineffective, right? Yeah, you will be having Ayan. I think so. You'll be giving the certificates for everyone. Khushi, should you wind it up?
No. Can we
Yes, sir.
access? Sorry.
Could you please provide the PPT?
Sure, Mahesh. Okay.
Thank you so
How we
much.
can access today's certificates? Sorry.
Organizers will let you know.
Mr. Shevin will be providing the certificates.
All right, with that, we come to an end with the question and answer session. So I would like to invite Manish sir for the vote of thanks.
Thank you
Okay,
so
yeah.
much.
So, hello everyone. Just wanted to say a big thank you before we wrap up. It honestly means a lot that you all joined today, that too on a weekend. I know weekends are for relaxing, so the fact that you took out time to attend this session really shows that how committed you are to learning and growing. Again, a huge thank you to Mr. Mohammad Hammaad Siddiqui sir. Your insights were super helpful for our audience, and we are looking forward to such more sessions in the future, sir. And thank you very much. So before we end, I would like to request everyone to please turn on your cameras so that we can have a snapshot. Just for a minute. Are we done, Ayan? Okay.
Manish, can I leave them?
Sure, sir. Thank you. Thank you very much again for joining and having a great time with us.
Thank you. Thank you so much for having me.
Thank you so much.
Thank you.
Thank you, everyone. You may leave now.